You are watching Morning Musings with Reinhard von Hennings, chairman and founder of Bridge House Law in Charlotte, North Carolina.
Cook fired for seeking religious freedom. Hello, this is Reinhard von Hennings, and the question now is, what are the lessons learned from this termination? Suncakes LLC, a Texas-based company operating under the IHOP brand, is facing a legal action from the U.S. Equal Employment Opportunity Commission, also known as EEOC. EEOC alleges religious discrimination and retaliation against one employee. The EEOC lawsuit claims that IHOP violated federal laws by refusing to honor a previously granted religious accommodation and subsequently terminating this employee for asserting his federally protected rights. Let's take a deep dive into the story. The incident involves a cook hired by Suncakes on one of the Charlotte locations in January of 2021. Upon being hired, the employee requested religious accommodations, exempting him from working on Sundays to observe his religious practices. Initially, the accommodation was granted. However, when a new general manager assumed the role a few months later in April 2021, the situation took a run for the worse. According to the EEOC complaint, the new general manager displayed hostility towards the religious accommodation and deliberately scheduled him to work on Sunday, April 25th and Sunday, May 9th. Following the May 9th shift, noting employee appeared on both of those shifts as scheduled, but following the May 9th shift, the employee informed the general manager, "Please don't schedule me anymore. I am no longer available on Sundays," noting that there was a prior agreement in place. In response to that, the general manager not only denied the scheduled shift accommodation, but also terminated the employment altogether. Disturbingly, after this was done, the manager made derogatory comments to other staff members, suggesting that religion should not take precedence and that the employee's job is not to be prioritized over church attendance, that he should take care of his financial responsibilities. Now, the EEOC, after the investigation, argues that Suncakes' actions are a direct violation of Title VII of the Civil Rights Acts of 1964. Title VII mandates that religious accommodations in a workplace are given and to protect individuals from religious discrimination and retaliation. Failing any pre-litigation settlement through voluntary conciliation process, now the EEOC has taken legal action and filed a lawsuit in the United States District Court here in North Carolina. What's at stake? The EEOC seeks different forms of monetary relief, payback, and compensation, as well as punitive damages. Also, the EEOC aims to secure an injunctive relief to ensure that ongoing religious discrimination is being stopped and that similar discrimination will not take place in the future. The regional attorney for the EEOC's Charlotte office emphasized that it is unlawful for an employer to take adverse action against an employee because the employee asserted religious rights. This lawsuit is now a general reminder that it is important to uphold religious freedom in a workplace and to identify what are legal consequences if staff members violate these rights. So what are the key takeaways from an HR point of view, from a legal point of view for you in your company? Religious discrimination is a significant issue in contemporary society. So what can you do to stay out of trouble? Number one, respect and accommodate. If you see other religious practices, respect them, accommodate them, and this case underscores the importance of mutual trust and respect. Employers should have clear policies in place about procedures, how to handle religious accommodation requests, and to ensure that all managers and supervisors understand their obligations to honor those requests and understand what is mandated under Title VII of the Civil Rights Act. Number 2, avoid retaliation. Employers must refrain from retaliating against employees who assert their religious rights. Retaliation can take different forms. It could be termination, just like in this case here. It could be negative comments. It could be some adverse treatment. It is essential for companies to foster a positive culture which encourages open communication and shows respect to employees all throughout the organization without any fear of reprisal. Number 3, train managers on anti-discrimination laws. Create an anti-discrimination policy and follow it. The IHOP case highlights that training is necessary. Supervision is necessary of the training. And if you educate your personnel, your HR leaders, it is the best step to stay out of legal trouble here. It can reduce the risk of those discriminatory practices to be implemented. Number 4, prioritize consistency, prioritize fairness. Companies should strive for the same rules for everybody. Strive for consistency, because consistency implies fairness. When there are religious requests out, make sure that they are all treated equal. By establishing such a consistent policy, it is less likely to be argued later in court, because when the policy is out in the place, it doesn't really matter that much if the policy is fair or not fair. It takes away from the randomness, from the argument here that this one was retaliated against. And lastly, number 5, seek pre-litigation resolution. The EEOC's attempt to reach a pre-litigation settlement is again a proactive way of stopping a suit to boil over. So if you are looking into creating an open dialogue with the aggrieved employee, it is better to have a positive dialogue. It's better to have a positive policy than to find yourself in court. Let's wait what the future will bring. As this legal battle unfolds, it is important to see the struggle from individuals in their world and in their life, how to make sure that their religious freedoms are being followed. The outcome of this case will have far-reaching implications for employees and employers alike, shaping the boundaries of religious accommodation and reinforcing the significance of protecting individuals from discrimination. It is not only here in this case where it boils down to religious beliefs, but retaliation in the workplace is never good and shall always be blocked by the proper policies. Have you reviewed your policies in your organization? If not, today is the day to do it.
Thank you for joining us today. If you would like more information about Bridge House Law, please visit our website at bridgehouse.law. Before you go, make sure to like this video and subscribe to the channel for more up-to-date content. Bridge House Law, business-minded, client-focused.
Whether you're a private citizen, an international business leader, or simply someone eager to stay on top of the latest news, this book is a great way to get caught up on the most recent developments in the worlds of international business, tax, politics, and social affairs. Go to morningmusings.com and order your copy today.